remain strong. I'm telling you, I'm very confident that the SEC will not win their summary judgment. The SEC has this case in New Hampshire. Why did they go to little New Hampshire? Why did they pick a little library company that raised $250,000, $200,000+? That's all, with all the billions of pump and dump schemes, of all the fraud going on in this country. What do? They go to New Hampshire and they pick a company that raised $200,000. Why? Because they had a favorable judge and they wanted to get a favorable ruling. And they have a case called Dragon Chain in the Ninth Circuit. And they have the Ripple case in the Second Circuit. As I've been saying for 2 years, it's a war. They're coming after crypto, and they're coming in different avenues, in different attacks, in different circuits, in different courts.
In today's video, Attorney John Deaton discussed the latest with the SEC Ripple XRP lawsuit, the recent summary judgments from Ripple and the SEC, and what's next for the procedural process, likelihood of a settlement soon. Before listening to him, please ensure to smash the like button and subscribe to the channel.
Tonight's discussion is about the decision handed down in the LBRY case, because there is a tremendous amount of FUD out there and confusion about what this case is and what this case isn't. What does this case mean to XRP holders in the Ripple case? Is that we have a judge that is in his 80s, and he is deciding this thing called cryptocurrencies and blockchain. And what he does at first, look what he writes. Right at the very beginning, he says, the nascent technology known as blockchain operates in the background of this dispute. It's not at the background. It's at the forefront of American innovation, what's going on. But he treats it as an afterthought. That's the first sign. As soon as I read that, I was like, oh shit, this isn't going to go well. So we move on next. And what do we see? We see something that XRP holders are going to start getting worried about if they think this case is going to be used as some kind of precedent. You see there that the LBRY co-founders went through some angel investors. It wasn't like an ICO. And look, they spent half of their pre-mined tokens on various transactions. Sounds a little similar, doesn't it? Ripple has sold XRP and things of that nature for their operations. Let's go on next. What do we see? We see the same exact thing here. The SEC sued LBRY, claiming that the LBC token is an unregistered security, that they didn't register it, and they seek disgorgement and injunctive relief and civil penalties. The same exact thing that they're alleging against Ripple, except in Ripple, they charge the two executives as individuals. Next in the decision, we see something very important for you to understand. You notice how the judge writes, the First Circuit has broken the Howey test into 3 parts. This case is in New Hampshire. It is part of the First Circuit. The XRP Ripple case is in New York. It is part of the Second Circuit. And you see here something very important to understand, everybody. In this case, LBRY, much to my dismay, they chose, and through their attorneys, when I say LBRY, I don't mean the executives, good people and all that, but their attorneys chose to concede the first 2 elements of the Howey test. The Howey test is a 3-pronged test. So going into the argument, going into the summary judgment, the LBRY lawyers gave up 2/3 of the test, right? The first test is an investment. The second prong of the test is in a common enterprise. And then the third prong of the test is that it is a reasonable expectation of profits derived from the profits of others. And so this whole case came down to that third prong, something that you cannot compare this case to the Ripple case because of that fact alone. Next, what we have, okay, we have basically the same kind of approach that the SEC is making. I'm going to explain why they did this. There's a reason that the SEC case was filed after Ripple, but finished first. And here's the reason. They had a favorable judge in a circuit that had different law, and they wanted to get a ruling in their favor to then go to the judge and say, look, judge, we can't have inconsistent law. This is what the judge in New Hampshire did. And so what they did is said, look at the statements that the LBRY folks have made, and they did the same thing in the Ripple case. Let's go next to what's said. All right, they basically, similar in Ripple, they talk about blog posts. They talk about, remember in Ripple, they talk about tweets from 2013. They talk about an email and all of that, where the CEO or others affiliated with LBRY talked about the token and the value of the token. Now, what's this remind people of, right? The judge here said that he took issue with the fact that LBRY's message was we're a work in progress and bear with us. Can you think of any other promoters out there? I know that Bill Hinman forgot that he met with them 5 to 7 times in 5 months, but remember Vitalik and Joe Lubin talking about the merge and how they first put a blockchain up that they knew wouldn't scale and that it was a progress. Didn't they say something similar like, bear with us? See, this is a very dangerous precedent, and it's why I've been saying that this case, the Ripple case, it's all about going after all of crypto, and that includes Ethereum. There's a reason that Gary Gensler will not admit that Ethereum is a commodity. The SEC using these statements saying that there's this overall messaging that they're going to drive the network and increase the ecosystem in the network, and therefore that will increase the token. But you notice here, all the XRP holders that are listening, look at that last line. It says, LBRY's messaging amounts to precisely the, quote, not very subtle form of economic inducement the First Circuit identified in SG. So this judge, what you need to know about this SG case is that the LBRY judge at the oral argument basically said his hands were tied because of this SG case, and he was going to follow this SG case. Well, the judge in the Ripple case does not follow the SG case, because the SG case is in the First Circuit, not the Second Circuit. Next. Okay, now this is the worst part of the decision. Absolutely. Read what I've highlighted in red. Right there you have it. The problem for LBRY is not just that a reasonable purchaser of LBC would understand that the tokens being offered represent investment opportunities, even if LBRY never said a word about it. That, ladies and gentlemen, is staggering. It is that buy, and this is where they're going to claim that Ripple is screwed because of the next language. Is it that by retaining hundreds of millions of LBC for itself, LBRY also signaled that it was motivated to work tirelessly to improve the value of its blockchain for itself and for LBC purchasers. Do you really appreciate how difficult, how dangerous that is? You're basically saying if LBRY said nothing, they never mentioned it, they took their approach, they said, forget it, we're going to the Bahamas and leaving this alone. Just by retaining the hundreds of millions of LBC tokens, that sent a signal. So that's where the XRP haters, right? They're going to come up here and say, look, LBRY retained hundreds of millions, Ripple retained billions. And let me tell people out there, I know the XRP holders are going to hate this, but I always told you I'm going to tell you like it is. The fact that Ripple didn't exist beforehand and that they were gifted it, it's a losing argument, okay? The same people were involved. So get yourself away from that. They're going to claim, the SEC is going to take this and they're going to quote it in verse, a long quote, and say, look, Judge Torres, this is what this New Hampshire judge in the First Circuit said. Okay, that's what the SEC is going to do. Remember, the SEC has this case in New Hampshire. Why did they go to little New Hampshire? Why did they pick a little LBRY company that raised $250,000 $100,000+. That's all. With all the billions of pump and dump schemes, of all the fraud going on in this country, what do? They go to New Hampshire and they pick a company that raised a couple $100,000. Why? Because they had a favorable judge and they wanted to get a favorable ruling. And they have a case called Dragon Chain in the Ninth Circuit. And they have the case, the Ripple case in the Second Circuit. As I've been saying on crypto law for 2 years, it's a war. They're coming after crypto and they're coming in different avenues and different attacks in different circuits and different courts. Okay, but again, the people don't listen to the people who say, oh, this is a death kill for Ripple, because it's not. Thing about this case, and this is another thing that people are going to say to you, and I'm showing you all the bad stuff so we can address it. It says, oh, well, utility will save XRP. And they're going to say, well, look, the judge addressed it. He said it doesn't matter that LBC token holders were purchasing LBC tokens for consumption. As long as it was offered as an investment by LBRY, it qualifies. Okay, and you notice that in the next slide, you'll see here that they go over that they can't reject the SEC's contention that LBRY offered it as a security simply because other people use the token, and that there's no case law that says that if you have a mixed use where there's consumption and there's investment, that it can't be a security. And so the judge default favored for the government. You see here where they basically said, according to the statements of the LBC holders, there were a couple hundred affidavits where they said they used the token to access the platform. Well, in the Ripple case, we have almost 3,000. But notice this judge is citing the Warfield case. The Warfield case is in the Ninth Circuit. That law does not apply in the circuit that the Ripple case is in. It's inapplicable. For example, I pulled the SG case and I looked at it. And in fact, in the SG case that the LBRY judge relies on, he highlights, in SG, it highlights the REVAC case, which is the Second Circuit, which is what I cite in the XRP holders brief and what Ripple cites in the Ripple briefs as controlling law. And in that case, it explicitly rejected broad vertical commonality, which deals with the common enterprise. Understand, it's a completely different circuit. It does not apply. What this judge said in LBRY, Judge Torres could read it and she could think, well, he makes a good point here. Oh, that's terribly flawed reasoning where he says it doesn't matter if the promoter says anything or goes away, it still could be a security. Judge Torres could have the same exact reaction that John Deaton's having, which is to be like, that is the most deeply flawed reasoning I've ever heard. Why is it the most deeply flawed reasoning? Because in 76 years of case law, ladies and gentlemen, not one time in the history of the United States from the Supreme Court since 1946 until today has there been an investment contract found when there is absolutely no connection whatsoever between the purchaser of the token or the asset and the seller. And when there is absolutely no connection, i.e. I've never heard of Ripple, don't know what they do with banks. I like this token. It works well on the ledger. I'm going to buy it. When there's that kind of situation, it doesn't apply. It's not an investment contract. So don't let this LBRY case get you down and think, oh, doomsday is here. Okay, I want to address the last couple things about what we do in our brief to the court. And here's a couple topics that we went over, where I just simply said no precedent supporting his theory. By the way, the SEC was relying on expert number one, who was going to get in our mind and say, this is what an XRP holder thought when he bought or she bought XRP, right? He was going to say all those things. But what happened? XRP holders challenged him. We filed an amicus brief, or a request for an amicus brief. Ripple challenged him on a Daubert issue. What did the SEC do? They backed away because at his deposition, he said, oh, I didn't know all that. Had I known that the XRP ledger, you had this utility about it and that people could actually use the ledger itself and get on the decentralized exchange, and it was being used in MasterCard and Visa and Uphold and all these other creds, these cards as a substitute for fiat. I didn't know that. And maybe I would change my mind. So they rescinded that. Then we get into how we get into what wasn't involved in the LBRY case. I cite to the judge the XRP debit card from Uphold, from the other cards that are being offered, the fact that people are getting paid in it. Here's another thing that doesn't apply to the LBRY case. Over 5 or 6 jurisdictions across the world have declared XRP a non-security. You've got the United Kingdom, you've got Japan, you've got Singapore, you got Switzerland, you got the United Arab Emirates. Okay? It keeps going on. You got all of these countries who looked at XRP and said it is a legitimate form of currency, medium of exchange. That does not exist in the LBRY case. All right, it's not even apples to oranges. It's not even fruit when you're making the comparison. Okay, and so we go into all of that. Also, that's not in the LBRY case. Spin the Bits, Tap Jets, right? All of these companies are saying, look how we use this asset in a way that doesn't involve Ripple. And so there's no reason to lose confidence. Let me tell you, this decision in LBRY sucks. This decision in LBRY, if I would have told the SEC to write the opinion yourself, they wouldn't have written it any better for them. Let me just be candid. But it is ultimately going to sit in the realms of history as a federal judge sitting in New Hampshire who followed case law that's not applicable where we're at in the Southern District of New York. And that's the thing to really take confidence with. Last thing I would want to comment on, what else doesn't apply in the LBRY case that applies to XRP? Well, a couple things we go over in our XRP holder amicus brief. 2014, the Government Accountability Office described XRP as a virtual currency in a decentralized payment system. 2015, the CFTC said Bitcoin and similar cryptos are commodities. In 2015, FinCEN settled with Ripple, declaring XRP virtual currency that forced Ripple to comply with the banking laws, not the securities laws. 2019, the framework that the digital asset framework for the SEC says this. It says a cryptocurrency that can be used immediately for payments or as a substitute for fiat is most likely not going to satisfy Howey. Can you think of a crypto that is used in immediate for payments and as a substitute for fiat? Can you think of one better? Well, guess what? In the Tap Jets amicus brief, they put in their survey where XRP killed all the other tokens as it relates to those two topics. Okay. Also, LBRY credits weren't used by MoneyGram in 2019 when MoneyGram filed forms with the SEC advising the SEC that they were going to use XRP in their cross-border payments system. Those are the things that we have that weren't in LBRY. I feel for LBRY. I tried to fight for LBRY. I tried to draw attention to the case because I knew what was going to happen. I knew that there's likely going to be this ruling for the SEC, and then the SEC would trumpet it out as though the Supreme Court in the United States had ruled, and that's just not the case. So remain strong. I'm telling you, I'm very confident that the SEC will not win their summary judgment when the judge rules.